Yes, Judge, good morning. 2 minutes, please, for rebuttal.
Okay, when you're ready, you may proceed.
Good morning, Your Honors. May it please the Court, Carlos Cabrera on behalf of the appellant, Veronica Duguay. In this case, reversal is warranted because the trial judge erred in setting aside the jury verdict because the trial judge improperly weighed conflicting or competing evidence, disposed of the jury's conclusion of the facts, disposed of the jury's conclusion of comparative negligence, and substituted it with his own conclusions. Excuse me. As a reminder, this case involves a couple of different duties, the duty to warn and the duties to instruct and supervise. I point that out because it appeared that the trial judge was primarily focused on the duty to warn and not the other duties. Addressing the competing evidence that the judge improperly concluded and substituted his own conclusions with that of the jury, I start with first where the court concluded that Ms. Duguay observed the flow rider for almost half an hour watching other patrons falling. Now this is very important because it serves as the evidence to support the court's conclusion that Ms. Duguay was aware of the dangers of the flow rider. The problem is that it was a contested or disputed fact. Ms. Duguay testified that she arrived late to the appointment and was rushing, and that her family was already in the flow rider room when she arrived. Mr. Malamud, the defendant's, I think it was corporate representative, testified that the flow rider sessions were 30 minutes long and the customers were told to arrive at least 15 minutes before their appointment so they can observe others riding the flow rider. Now, for the judge to come to this conclusion based on that evidence that she observed other riders for 30 minutes, he must have just weighed the evidence and come to his own conclusions and considered the credibility of the witnesses, which is improper pursuant to...
Well, didn't she say that she watched everybody in line as she was waiting for her turn at the ride?
She did say that she saw some members of her family go on the ride before. That is true. But it's not... But
She saw all of them wipe out.
they all did fall, yes.
She saw that.
She did testify to that, yes, Judge. Okay. Another competing fact that I believe is extremely important is the court's conclusion that Ms. Duguay let go of the tow rope and she alone made the decision to let go of the tow rope. This is a really important fact because it goes to the heart of the plaintiff's negligence claim. One of the plaintiff's main contention is that Carlos Arce, who was the gatekeeper, the person who was supposed to instruct and supervise the riders, he had testified in his deposition that he let go of the tow rope. Now that testimony changed at trial, and he then said, oh no, I didn't, that was a mistake. I didn't let go of the tow rope, it was Miss Duguay. That was his testimony. It was conflicting at the very least. Miss Duguay testified that she couldn't really remember if she had dropped the tow rope or if she still had it in her hand when she fell. It was up to the jury to determine the credibility of the witnesses, including Mr. Arce's conflicting statements. His deposition testimony was one thing, and at trial it was another.
Did you have any expert testimony regarding standard of care and whether the signs that were present were adequate? Any evidence like that?
There was no expert testimony, Judge. We believe that no expert testimony was necessary, simply because I think that the jury could use its common sense to determine whether or not this was...
Well, how would the jury, I mean, within its general knowledge, know about how one of these rides or amusements is properly managed and has proper safety protocols in place?
Well, there was evidence of the procedures.
By the way, I would agree that a reasonable person can look at signs and say, yeah, you know, they're properly posted, they're in a conspicuous place, they show, you know, they're in bright letters, large letters that people can read easily. That's the kind of thing I would agree with you with respect to this trial, in this context of this trial, that you don't necessarily need expert testimony for that. But with regard to safety protocols and how this ride is operated and what's required in terms of training for personnel, et cetera, you still think that's within the common knowledge of a jury?
We do believe so, and the reason why is because I think it's within the average person's common sense whether or not a rope can provide stability to a rider on this turbulent water. I mean, the procedural manual don't provide for that. The procedure manual say for inexperienced riders, the instructor has to stand there and basically spot the person. They chose out of their own whim to change that policy and instead use a rope, which obviously to me, it doesn't provide the support that does someone spotting you, who's actually holding you. So that's why
How would a jury, using their ordinary knowledge and experience, know that that would be required? I mean, how would they know the speed of the water, the configuration of the ride?
Well, I do believe that there was some testimony. I think it was presented by the defense that I believe it was like 30,000 gallons of water rushing, and there was testimony as to the procedures manual was, I believe, admitted into evidence, and there was all this explanation as to what was supposed to have happened, which didn't happen. There was no evidence that they actually complied with these procedures that they themselves had in place. They were supposed to have a training video. They didn't have the training video. There was a number of things that they were supposed to do that they didn't do.
I understand, but you talked about the 30,000 gallons and all that stuff. But as a juror, how would a juror in their ordinary understanding and knowledge and everyday experience know what that really means without having expert testimony to explain either the force that is generated by this and the impact it would have on somebody trying to stand, and navigate this on a surfing type of motion?
Right. Well, again, Judge, and I'm not sure if I'm understanding the question. I mean, I think I understand the question. I don't know that I have a precise answer for you, other than to say that the defense did have an expert, and they did get into this to a certain extent. So that kind of information was presented to the jury, to the extent of, the force of the 30,000 gallons and all that. I don't know how detailed information was provided to the jury with regard to that, but I believe that there was enough evidence coming from the defense side, from their own expert, explaining what was involved in this ride. And for our purposes, we believe that one fact is critical, because again, it's conflicting evidence that the judge, on his own will, disregarded the conclusions of the jury and weighed the credibility of this witness, specifically Mr. Arce, who said he had dropped the rope, which would have caused Ms. Duguay to fall, but he changed that testimony at trial. How can the judge make that conclusion and say, oh no, she alone made that decision to drop the rope, when there was no evidence to really support that? She herself testified that she couldn't remember if she dropped the tow rope or if she had it in her hand when she fell.
You're into your rebuttal time.
Oh, I'm sorry. Okay, Judge. I guess I will.
I'll give you a couple extra minutes.
Okay, thank you, Judge.
May it please the Court, Diane Tutt on behalf of the appellee. I see the appellant's arguments falling into two different categories. The main category, which seemed to have been argued in the briefs, was the adequacy of the warnings given, and then the other category being all of these alleged violations of the guidelines. I'm not sure if counsel is still arguing about the warnings, because he didn't really make much of an argument, but I'll be brief on that. The case law that we cited in the answer brief shows that when a plaintiff has not read the warnings, the insufficiency, if they are insufficient, cannot be the proximate cause of the injury. So the evidence was very clear. There were numerous posted warnings throughout the facility. She said, I'm not sure if she said she didn't see them or she didn't read them, but clearly she didn't read them. In any event, we contend they were sufficient, because one of them, which was read to her and she asked whether she saw it and she said no, specifically details the nature of what happened to her, which is that this is an extreme sport. You will, everybody agrees, you will be leaving that surfboard at some point and falling into the water. There's no question. The particular warning that I'm speaking about said that you will fall, and falling may result in the participant's body striking the surface of the flow rider with great force. So that's what happened. She is presumed to have read them, and she simply cannot challenge their insufficiency at this point. And I would also point out that...
Well, she also said that she didn't know that she was never warned that she was going to fly up in the air and twirl around and then come down.
That's what they're arguing on appeal. They didn't actually argue that at the directed verdict hearing below. All that they really argued at the directed verdict hearing below on that issue was, this is a jury question. The jury heard all the evidence about the warnings. This was a jury question because the defendant itself should have given a verbal warning to her as opposed to relying on the signs. That's what they argued. They didn't argue that if she had gotten a warning about flying up in the air, that would have made a difference. And again, I think it goes to the sufficiency of the warnings. I mean, the case law from this court, Clark versus ODV Holding, and also the Lopez versus Southern Coatings case, which we cited in the answer brief, both say that if the plaintiff does not read the warning, the insufficiency cannot be the proximate cause of the injury. So I don't see how a reversal is warranted on the warnings issue. That is clearly what the court focused on. Did he say everything exactly correct in the order? Perhaps not. Perhaps she didn't watch the other riders for 30 minutes, but she saw 2, possibly 3 members of her party go before her. It was her stepfather, her brother, and her fiance. She couldn't remember whether her fiance went before her or after her, but she clearly said, I saw my brother and my stepfather go on the board, and they wiped out, they fell into the water. That risk was clearly known to her, and there's a multitude of cases that say you don't even have to warn if the danger is known to the plaintiff. Now,
so if I understand you correctly, when we look back at what the trial judge did here, we're supposed to basically say, well, he made a few mistakes on the facts, but treat them as superfluous to the substance of the case, which is that a reasonable juror viewing the totality of the evidence could not have found for the plaintiff in this case under a failure to warn or failure to instruct or supervise theory.
Yes, and I if this order was replete with mistakes, I think perhaps maybe that wouldn't be the rule. There's one mistake that was mentioned, this whether she observed it for 30 minutes or not, and that's really the only potential error in the order. And I don't think that makes a difference. I think that the solid issue is whether a reasonable jury could have ruled in favor of the plaintiff based upon the evidence and based upon the law that is now cited to your honors. And I think that's important because the sufficiency of the warnings cannot possibly be the proximate cause, considering the law on that subject and the fact that she knew that she was going to wipe out. Regarding all of this other stuff about the guidelines, there was a manual. This is some kind of a franchise operation. There was a manual produced by the manufacturer of this flow rider device or this ride. And other than one thing, all of these suggestions in the manual were guidelines. So they come into the category of internal rules or guidelines. And the case law on that says, and that's the Artigas case, and the Steinberg case cited in my brief, the law on that is that when it comes to internal rules or guidelines, they do not set the standard of care. There must be evidence of the standard of care, and then if there is, the jury can be instructed that you may consider this along with what you've heard about the standard of care. There was no expert here, and I think the lack of an expert is very critical on several matters. Number one, what we're talking about, these guidelines. There was no expert for the jury to hear say, well, they should have played a safety video, or they should have done this, or they should have done that. There's 5 or 6 things in the initial brief that counsel has suggested were violated from these guidelines. but there's no expert to tell the jury what the standard of care is on any of these issues. I don't know, I agree, I don't think that they really needed an expert on warnings, but that's a completely different issue. That's why I say the plaintiff has broken out his arguments, warnings, and then all of these guidelines. I do think that they needed an expert on the guidelines. I also think that even though I don't think it's preserved by any argument at the DV hearing, I think they needed an expert, a human factors expert or somebody that would have said that this flying up into the air, which is now their theory, would have made a difference. Honestly, the jury had no way of knowing whether any of this, they would have to speculate that holding a rope versus the arm, flying up in the air, any of these things would have made a difference in her injury. This facility knew that people could get injured by the sheer nature of the ride. They warned people that that was a possibility. And the plaintiff had the burden, I believe, that they were going to rely on any alleged lack of handling the procedures in the guidelines, had a duty to show the proximate cause between that violation, any of those violations, alleged violations, and her injury, and they simply did not do that. I do not believe this court should accept counsel's statement that, well, of course a jury could determine that holding on to a rope is less safe than holding on to a hand. I don't see how a jury could do that. If your honors, I think there's a picture of the actual rope situation, if you wanted to look at. I think it's at page 156 of the exhibit record. Let me just caution, though, that shows a fairly long rope. It shows the person on the solid concrete, and then a person on the customer on a surfboard, holding onto a rope with the person on the bank, if you will, holding onto the rope. The testimony was that the rope in that picture was was longer than the rope here. So, but the idea you can glean from that picture, it was a little shorter in this particular instance. But the bottom line is that I don't see how any person, except possibly an expert in these types of things, would be able to determine that holding onto a rope was less safe than holding on to someone's hand. And this wasn't changed from the manual due to a whim. The owner testified that they tried holding on with the hand and found that the hands were slippery and it was not safe. There was a tendency to the slipperiness for the instructor and the client to not make good adherence between their hands. And that's why they went with the rope. And again, there's absolutely no expert testimony to contradict that or to show that anything that this facility did was in any way unsafe or, more importantly from a legal standpoint, in any way breached a standard of care. The trial judge was correct and should be affirmed. Thank you.
Thank you, counsel. Rebuttal?
Thank you, Judge. I'll try to be very brief here. With regard to the warning signs, all I'd like to say is that even if the signs adequately warned Mr. Duguay of the dangers, it would only discharge Adrenalina's duty to warn. We still have the other duties that we're talking about, instruct and supervise. Even if, and I'm citing to DeCruz Hamer versus Festival Food Market, that's a case out of this court, I believe it's Judge DeMorgian's case, that says even if the warnings were adequate or the dangerous condition is deemed obvious, this generally creates a question of fact regarding the plaintiff's own comparative negligence. In this case here, the jury found the plaintiff comparatively negligent. To completely dispose of that, I believe, is error. To completely dispose of the trial judge just completely disposing of the jury's finding of comparative fault and, of course, of the facts. But
the bottom line is, if this defendant had done everything in their power to instruct and everything in their power to supervise, this injury still could have resulted in the very manner in which it occurred.
Except that there's evidence that, at least according to the guidelines, that they were supposed to do things a certain way. They were supposed to have a spotter. They didn't have a spotter. There's some testimony from Mr. Arce that he dropped the rope, which could have caused her to fall down. Of course, he changes that testimony at trial and says, oh no, that was a mistake in my deposition. You know, she dropped the rope. And I think that's a very critical fact here, because the jury could very well have decided this case by saying, you know what, I don't believe Mr. Carsey.
Could she have fallen down without dropping the rope?
She could have, but during the time that they were, at least what the evidence shows is that during the time that they were holding, each of them were holding the rope, she wasn't falling. She might have eventually have fallen, but the testimony is, again, is conflicting. And I think that's where the problem is, because there is conflicting evidence. I don't believe it was up to the judge to decide what the facts were. That was the jury's job.
If there had been a spotter, would that have stopped her from falling too?
Quite possibly. That's something we're not sure. I mean, eventually the ride does end in a fall. I mean, that's true. But
Right, everybody falls.
Eventually everyone does fall, but not in the manner that she saw and that she was warned about. She was flipped in the air. That warning was only in a document that was never provided to her. So
Well, it was posted behind the cashier, wasn't it?
only that you would fall. The whole flipping in the air was not
Oh, hold on.
posted in the. That was
The sign behind the cashier. Furthermore, riding may result in the flow of water picking you up and pitching you head over heels onto a tension fabric or rigid fiberglass or PVC subsurface. Isn't that really what happened here? I mean, that warning is really what happened here, isn't it?
Well, I believe that warning is in the release waiver form. I don't believe that was posted. I don't believe the evidence showed that it was posted.
I think, well, okay.
Judge, just to summarize.
Yeah, you're out of time, but
Okay.
5 seconds.
Okay,
Wrap it
well,
up.
we believe that the judge improperly weighed the evidence, considered the credibility of the witnesses, and disregarding the jury's findings and jury verdict. We believe that the final judgment should be reversed and the jury verdict be reinstated.
Thank you.
Thank you.